Hey guys, this is Cam from BusybodyBusy.com, and today we're going to talk about a Supreme Court case. It's an interesting one to me. It's a case from 2023 where the Supreme Court essentially ruled that looks do matter. Okay, so the case is Munoz versus the Department of State. So according to the brief, what happened is that Sandra Munoz is an American citizen. She married a man from El Salvador in 2010. So this was a long-term marriage. So probably an IR1 visa that they were applying for. And she tried to get a visa for him and was denied. According to this, they went to the consulate in San Salvador. They had several interviews with them, which is not usual. Normally for marriage visas, there's only one interview. So already they knew they should have known they were in trouble. And after going through all these interviews, they were denied. And they weren't given a good reason. The husband guessed that maybe they thought he was a member of MS-13. That's like a notorious gang from Latin America that is talked about in the United States quite frequently, especially those who want to limit immigration. I guess he had a tattoo that was similar to a tattoo that is worn by those who are in MS-13. So the husband disavowed his membership, said, hey, no, you got it all wrong, not a member. Can you please let me in? And the consulate said no. They applied its section in the law, 1182, that basically says, this section basically allows the consulate to deny someone if they think that they're going to the U.S. to commit crimes. And so after they appealed, the council said no, they tried to sue. Now, here's the thing. In the U.S., courts typically defer to the administration, i.e., in this case, the State Department. Courts don't really like to get involved in these kinds of cases, although recently it's been happening more and more for political reasons. So that's why initially Munoz's case was dismissed, because, as I said, courts like to defer to the government when it comes to immigration. However, she appealed to the Ninth Circuit, which, by the way, is the most liberal circuit in the court system in the U.S. It's also the most overturned. And the Ninth Circuit, first of all, made them give them the reason, which, of course, was what they thought, because they thought he was in MS-13. But they also said that, let's see, her argument is that she had a constitutionally protected liberty interest in her husband's visa application. And so basically, and the court said that by denying her husband and not even giving them the reason, that the State Department violated the Due Process Clause. And also, because they wouldn't tell her the reason, that they forfeited their entitlement to insulate its decision from judicial review under the doctrine of consular non-reviewability. What this is basically what I told you, that the government has broad authority to determine who comes and goes into the United States. And they don't want people to be able to appeal in court because, one, that would clog up the courts, because basically everybody who wants a visa would then just try and sue to get in. But two, it's a national security issue. So, of course, the case just went up the appeals process, and it made it to the Supreme Court in 2003, where the Supreme Court ruled in a 6-3 decision that, indeed, the government does have broad authority to determine who comes and goes in the United States, and that immigration is not a right, even if you're being sponsored by a U.S. citizen. And so I think that's so interesting, because in America, Americans will always talk about rights, we have rights, and what the government can't do, but not when it comes to immigration. When you apply for a visa to the United States, The law says the visa officer must consider you to be an immigrant by default. And it's up to the applicant to prove that they're not. That's very antithetical to what we as Americans think of when we think of our justice system, right? Because it's the other way around. Innocent until proven guilty. Not with this. And that looks do matter. I've always coached my clients, when you go to an interview, you need to look the part. The visa officer, the United States received 9 million immigrant application or visa applications in 2022. That is the most of any country in the world. It would be great if visa officers had like an hour per case to sit down and review and just make sure they're getting a decision right. And that would be ideal because, this impacts people's lives. Being approved or denied a student visa is a life-changing decision for somebody. But that's not the reality. The reality is that they've got 3 minutes to decide whether or not to approve or deny you. And so that's why it's so important to look the part. But for example, if you are applying for a student visa from India, right? The visa officer knows, okay, a good student from India who intends to go back to the United States looks like this, dresses like this, talks like this. So if you don't fit that profile, the automatic assumption is deny. They're not a real student. So that's why if you don't fit the profile of what they're expecting, you darn well better be able to explain why. And same thing with a tourist. The U.S. is very expensive, so very few people from developing nations could afford to travel to the U.S. So if you're applying for a tourist visa and you want to go to Disneyland, well, Disneyland is expensive. So I'm going to want to look at you and say, okay, this is what a typical tourist from the Philippines looks like. Their English is good. They wear certain clothes. Their hair is nice. Actually, hair is one of the big things that they look at. How well you take care of your hair. And so if someone doesn't fit that, the assumption is going to be immigrant. And I just thought this was interesting because having an American sponsor usually does help you. For example, CR1 visas have more weight than a K1 visa. And K1 visas have more weight than a tourist visa. Why? Because an American is sponsoring you for those. And the U.S. considers marriage to be a stronger bond than a fiancé. That's why the CR1 they give more consideration to the CR1s than K1s. And obviously having an American sponsor you, they've signed the affidavit to support your IA. But even then, it's up to the person interviewing you. They have broad authority. There is appeal for certain visa classes. A large majority of the appeals are denied. So it's really important to get it on the first time. So if you're applying, and one thing that really bugs me about some of these visa companies, they try to make it sound like, oh, if you get denied, oh, that's okay, we can help you and get approved. 214B denial, which is the most common, is really bad. And it stays on your record forever. And it makes it that much more difficult. So if you imagine getting a visa as climbing a mountain into the promised land, each denial, especially a 214B denial, makes that mountain that much taller. That doesn't mean it's impossible to traverse this mountain, but it's really hard. So getting denied is a big deal. So one 214B denial is too much. It's too many. So that's why I always recommend, if you're not sure, have someone who knows what they're doing help you, so you don't have a 214B denial on your record. Thanks.